In July 2025, California Governor Gavin Newsom participated in a 4-hour recorded interview in Tennessee with Sean Ryan, a former Navy SEAL who became a conservative podcast host and departed with something no one anticipated: a Sig Sauer P 365X macro pistol, a firearm that sells for approximately $700, presented to him live on camera as a present. Newsom smiled, grasped the case, and declared immediately, "Brother, this is absolutely wonderful. The last thing anyone would anticipate is that I truly appreciate this present. I'm not against firearms at all, yet here is the detail that makes this worth every single moment of your focus." 8 months afterward, when Newsom submitted his required ethics report in March 2026, the documents displayed that firearm right beside wine, a 49ers passes, and $21,585 in sponsored Brazil trips. And in the remarks section beside the firearm entry, it stated, "Presently held by a licensed firearm merchant and clearly not in the governor's custody." His own staff needed to retain external legal advisors merely to determine how to transport the firearm from Tennessee to California lawfully. And the governor of the most controlled firearm state in America received a weapon on camera, complimented it, publicly paid personally to keep it beneath the state's $630 present limit, and still cannot transport it home. Here is what it truly requires for any California resident, including the governor himself, to lawfully transport a firearm home. And each one of these stages is a regulation that exists right now in 2026. Because the Sig Sauer was presented in Tennessee, it cannot merely be transferred or shipped. Federal regulation mandates it to travel from a licensed merchant in Tennessee to a licensed merchant within California before anyone can handle it, and that transfer alone requires money and duration. Once it reaches California, Newsom must personally appear in person at the merchant. No aid, no proxy. Finalize the merchant record of sale documents. Provide his fingerprints, display his driver's permit, supply a paper verifying his present residence like a utility statement, and endorse an affidavit confirming he has physically inspected every firearm he currently possesses within the previous 30 days. Following that arrives a compulsory state background screening, a written firearm safety credential test, where he must achieve at least 75%, and then a 10-day cooling-off period before he can come back a second occasion to actually obtain the firearm, with combined charges and taxes on a $700 firearm totaling nearly $300. Gavin Newsom has invested more than a decade constructing California into the most supervised firearm state in the whole nation. As lieutenant governor, he personally financed and advocated for Proposition 63 in 2016, the initial regulation in any American state mandating a background screening merely to purchase a container of ammunition. And since assuming the governorship in 2019, he has approved over a dozen significant firearm measures, including an 11% excise levy on every firearm and every container of ammunition sold in California, the first ever state prohibition on new Glock handguns, limitations on phantom firearm components, universal compulsory secure storage for every firearm owner, irrespective of whether minors reside in the residence. And he even suggested revising the United States Constitution with the 28th Amendment to prohibit assault weapons nationwide, a proposal that not a single other state supported. The individual who constructed that ranking segment by segment, measure by measure, signature by signature, is the same individual whose own firearm has remained unclaimed at a licensed merchant for 8 months, while his staff retained external legal advisors merely to comprehend how to recover it. Just one straightforward inquiry for you in the remarks. If the governor of California cannot maneuver California's own firearm regulations, how is an ordinary working resident expected to accomplish it independently? On June 20th, 2025, a 3-judge panel of the 9th Circuit Court of Appeals, historically one of the most progressive federal courts in the nation, voted unanimously to invalidate California's one handgun per 30 days acquisition regulation in a case titled Nguyen versus Bonta, determining it a clear infringement of the Second Amendment. A Judge Danielle Forrest authored in the decision that the Constitution explicitly safeguards the right to bear arms, and that the court was not conscious of any circumstance where government may temporarily restrict the exercise of constitutional rights in this fashion, meaning no government can lawfully impose a time restriction on how frequently a resident exercises a constitutional right. The same way no government government could inform you that you can merely vote once every 30 days, or merely attend worship once monthly. California attempted to defend the regulation by referencing a colonial-era Virginia rule, but the court dismissed that argument completely. And by August 14th, 2025, the Ninth Circuit delivered its formal order, making the decision lasting. I'm marking the first occasion in history that court has invalidated a California firearm regulation outright for infringing the Second Amendment, as if the existing regulations were not already complicated enough. January 1st, 2026 introduced a fresh layer of legal mandates for every single firearm owner residing in California. Senate Bill 53 broadened the state's secure storage regulation so that it now applies universally to every inhabitant, irrespective of whether minors reside in the residence, meaning the moment a firearm is not physically on your person or within your immediate reach. It must be secured inside a California Department of Justice approved firearm safe, or fastened with a DOJ-certified locking mechanism. And a first infraction is a violation. A second infraction is another violation. But a third infraction becomes a criminal misdemeanor on your lasting record. Alongside Senate Bill 53, California also acted aggressively in 2026 against phantom firearms, which are homemade, untraceable weapons constructed from components or 3D printed elements that carry no serial number and cannot be traced by law enforcement. With Assembly Bill 1263 and Senate Bill 704 now mandating that firearm barrels, frames, and receiver components can no longer be delivered directly to a purchaser's residence and must instead travel through a licensed merchant with a complete background screening, with statistics showing phantom firearms accounted for approximately 30% of all weapons recovered at California crime locations in recent years. Just a few months after accepting the Sig Sauer on camera in July 2025, Newsom approved Assembly Bill 1127 into law in October 2025, making California the first and sole state in the entire United States to prohibit licensed merchants from selling new Glock handguns and comparable pistol models, a regulation that took full effect for merchants on July 1st, 2026. And the cause this specific prohibition matters so significantly is because Glock is not some uncommon specialty weapon. It is the single most favored handgun brand in America, carried daily by an estimated 65% of all law enforcement personnel across the nation, including numerous California police divisions, and owned lawfully by millions of ordinary American civilians who selected it specifically because of its dependability and straightforwardness. The regulation targets these handguns because certain Glock models can be unlawfully altered with a small 3D printed apparatus called a switch that transforms the pistol into a fully automatic weapon. But critics immediately observed that the prohibition penalizes every law-abiding purchaser for a modification that is already unlawful under both state and federal regulation. Here is what we want to discover from you in the remarks. Should a single unlawful modification be sufficient cause to prohibit an entire category of the most widely owned handguns in America? Whatever your stance on firearm control, what this entire circumstance exposes is something that impacts every single law-abiding firearm owner residing in California right now. The state's firearm regulations have developed into a layered labyrinth so complicated that even the most influential elected official in the state, surrounded by a complete legal team, needed to retain external counsel merely to determine how to lawfully recover one single pistol that was presented to him as a present. And ordinary Californians with no legal team, no government income, and no political ties encounter this exact same labyrinth every single occasion they attempt to exercise a constitutional right. California has approved over 40 significant firearm-related regulations since 2019 alone. The state imposes nearly $300 in combined charges and taxes on a single $700 firearm acquisition. Firearm owners must now adhere to universal secure storage regulations, insurance disclosure mandates, ammunition background screenings, phantom firearm component restrictions, a fresh Glock-style prohibition, and an 11% excise levy, all piled on top of each other, while simultaneously observing federal courts begin invalidating those same regulations one by one, with the Ninth Circuit already determining the one firearm per month regulation unconstitutional in 2025, and additional legal challenges actively advancing through the courts against Senate Bill 53 and other recently approved restrictions.